Hello, Assalamu alaikum. So, how are you all? So, today I'd like to talk about the independence of judiciary in Bangladesh. You know that independence of the judiciary is the basic term for expressing the justice, equity, and good conscience in Bangladesh. And it is the most deserving doctrine in Bangladesh to make a basic independent of the judges in Bangladesh. But you know that in the Bangladeshi practice, in the Bangladeshi concept, there are no independence of the judiciary. According to Article 22 of Bangladesh Constitution, it is said that judicial authority and judicial authority's activities will be different from the executive authority. This is not my direction. This is the direction of the Masdar Hossain case. And very recently, Masdar Hossain was questionable for his activities, and his certificate of Bar Council has been postponed. But I will not go to the term of Masdar Hossain case. I will seek the judicial independence from the Montesquieu's separation of power. So what do you mean by the separation of power? Separation of power means states three organs: executive authority, judicial authority, or even the legislature authority. They will be free from any kind of encumbrance and supervision of the another body. But in Bangladesh till now we did not get any kind of single example of the judicial independence in Bangladesh. According to Article 95 and Article 115 of Bangladesh Constitution, it is said that President will appoint the judges of the Supreme Court. This is the direct violation of the separation of power. It is also said that absolute separation of power, it is not desirable, it is not acceptable. But I will not go to the term of separation of power. I will go to the term of checks and balance. But you know that checks and balance theory is not applied yet in Bangladesh for making a very good judicial independence in Bangladesh. Stop karo. Okay. So that I have already mentioned, the judicial independence in Bangladesh. So most of the philosophers and political thinkers, they think that if the judiciary is independent, there will be create a basic burden. The burden for the political leaders, the burden also for the government. Even the government can't influence the judicial officers in the regard of judgment, in the regard of different kinds of order that given from the court. For example, before 2004 or in the age of 1980s, there was no independence of the judiciary in Bangladesh. For the first time in the year 2008, by the case of Masdar Hossain case, this case prelude that the judicial authority, I mean that the judicial body, the judges, the judge officers, judicial officers, even the magistrates, they will be free from any kind of political affiliation of our administrative system. So in the administrative system in the year 2007, the judicial authority has been departed from the executive authority. So from 2007 to 2026, there was no types of single judicial independence in Bangladesh. So what is the reason behind that? In the constitutional measurement, we are saying judiciary will be departed from the executive authority. It is mentioned in Article 22. But you know that Article 22 of Bangladesh Constitution, it is not judicially enforceable. It is also mentioned in Article 8.2 of Bangladesh Constitution. That means that from Article 8 to Article 25 of Bangladesh Constitution, it is not judicially enforceable. That means it is the BOID of the Constitution. That means these are the ornaments of the Constitution. This also believes the fundamental principle of Bangladesh Constitution. So this is the basic philosophy of Bangladesh Constitution, is that on hand Bangladesh Constitution is say about the independence of the judiciary, but in practice practical impact of Article 95 and Article 147, even Article 115 and Article 116 definitely believe that judiciary is not getting any kind of judicial independence from the appointment process. So in the days earlier of Bangladesh Constitution, whenever the Bangladesh Constitution has been made in the year 1972, in that time the judicial independence was ensured by the Bangabandhu Sheikh Mujibur Rahman's Constitution. I mean that 1972's Constitution. There is a process of judicial commission. This judicial commission will be independent, impartial, and free from any kind of political affiliation in Bangladesh. But the problem has been arrived in the year 2011, whenever the 15th amendment passed by the former Prime Minister Sheikh Hasina's government. So from 2015 to 2026, we are getting lots of delusion lots of defamation about the judiciary, but it is actually not true. We have to give the absolute independence to the judicial officers, as we can't able to get the access to justice from the judiciary. So this is the basic burden of our judiciary. First of all, the judge need the political independence. Secondly, the judge need the formal independence. The third reason is that judge will get the absolute internal independence. The fifth reason is that the judge will get the appointment independence. So if it is possible to ensure the four kinds of appointment certificate or four kinds of ensurety in the process of judicial independence, I think that in that time Bangladesh judiciary will be getting more independent in giving and appointing different types of judgment procedure. Otherwise, it's actually not possible for the Bangladeshi government, for the judiciary, even for the administrative authority to provide the higher independence of the judges. So the question may arise, why our judicial independence is basic need in Bangladesh constitution? As you know that the judge is the highest authority. The judge is the last resort to get the judgment. So if it is not possible to make it impartial in giving the judgment or judgmental procedure, I believe that it's actually not the justified way to provide the judgment in this regard, and by this way people will never accept the access to justice, rule of law, even people will not get the equitable principle from the court. For example, one of my professors, whenever I was in my university, he said that whenever the judicial officers, they will never be independent. Our judicial officers, they will not provide any kind of judgment which is rational, which is equitable, affiliated, even which is essentially relevant for the people's welfare or development. Even the Indian former Justice Mukherjee once said that judicial authority must be independent, because if the judicial authority is independent, people will get the justice with a very short time. There will be no burden, there will be no issues of backlogs of cases. For your kind convenience, till now, till 2026 23 April, in our judiciary 40 lakhs suit is actually pending. So how it is possible to provide a very good judgment during the time of huge amount of justices which is pending, which is untold? So in that time, the informal judicial system, I mean that ADR procedure or non-legal ADR procedure, it can be a satisfied way to provide the judgment for the satisfaction of the judiciary in Bangladesh. While I'm talking about the independence of the judiciary in Bangladesh, in that same procedure I have to also talk about the executive independence of Bangladesh. You know that the executive authority is not changing in Bangladesh. The government is changing, judiciary is changing, but executive authority, they are not changing. They are just changing their position. For example, before the 5th August, there was a DC, there was a ADM, there was a ACJM, there was ACMM. This man is actually right now existing in our administrative procedure, but their designation has been changed. For example, who was DC in the previous time? Right now, he is the advisor of Bangladesh government. So I believe that the executive authority, judicial authority, even the other authority has been changing, but the judicial authority is not changing. So this is the biggest fact of our judicial